bearing in mind that you have been the victim of a very serious threat of violence.
Yes, Judge.
And am I also right that you think that the trespass to your property, especially your mail, is very significant indeed?
Yes, Judge.
And you would like to form a counterclaim based upon those two legal principles?
Yes, Judge.
No.
Now, just to be clear, your claim is not restricted to the £500 principal sum of the loan. You also have an additional amount as well you'd like me to consider, correct, sir?
Emotional distress.
Emotional distress?
Yes.
And how much is your emotional distress worth, sir?
£2.5 grand.
£2,500? Be quiet. Please, sir, could you explain that to me?
The reason is that I've been considering worrying about this money not coming back to me. I've been rushed up to Basingstoke Hospital under a heart attack.
Because of the worry?
Yeah. And now I'm under a load of medication, pills.
I accept that this has caused you some distress. I accept it's caused you worry. You say the fact that this gentleman hasn't paid you back has caused you worry to the extent that you're entitled to sue him for £2,500 for the physical effects of him not paying back your debt.
I was fit enough before, no, I'm not now.
Understood. Trevor, Chris, there are two parts of this claim. Trevor, you are suing Chris for non-payment of a loan. In nearly all cases where you know an individual, they're a family member or a friend, a loan is not recoverable because you don't have an intention to create legal relations. In other words, the parties didn't intend that in the event the person didn't pay it back, you were going to end up in court. The way that you rebut that presumption is by putting it in writing. In this case, you didn't have anything in writing except a text message. However, I'm satisfied by the narrowest margin that that text message was contemporaneous. In other words, it was around the time the money was handed over. What's more, even if I was not satisfied about that, Chris, you lied in order to obtain this loan in the first place. In those circumstances, Trevor, I award you £500. As you've already understood, you are not entitled to charge interest, and that offer was made in stupid circumstances which are not enforceable. So I dismiss out of hand the £2,500 that you've applied for emotional distress. I believe that you've suffered some physical effects as a result of this gentleman not paying you back, but that's not recoverable. Chris, at the beginning of this case, I thought I would deal with your counterclaim in a very short period of time. It is very difficult to claim for emotional distress. You have to prove that you've suffered a real consequence as a result of somebody's behaviour. In the course of these proceedings and hearing Trevor's evidence, I am satisfied that you do not have a claim for emotional distress. You have a better one. You have a claim for harassment and for trespass. Trevor had no right whatsoever, first of all, to take your mail, and secondly, through an indirect party, make threats against you. That, sir, was a straightforward harassment. Worse still, it seems to me that it may have been unlawful. In those circumstances, I'm satisfied your better claim is for nuisance, not for emotional distress, and I'm able to give you an award connected to that nuisance. This court awards you £500.